Okay, well, welcome everybody to level 2 of A Practical Road to Freedom, class 6. Now, earlier in the first class, I had announced that tonight we're going to talk about administrative approaches, administrative proceedings, how to handle the bureaucrats, and tax court. But after some thought and reconsideration, I felt that you guys will get more out of that class if I put that at the end of the level 2 rather than beginning. Reason being, because in tax court you are dealing with court procedures and court proceedings. Well, I ought to do the classes on more court procedures, which is class 7, and analysis of the court case, class 8 first. So you get some more practical experience, or some instruction, I should say, on court procedure before we go into a tax court, which is it's really a tax arena, even though it's part of the executive branch of the government. So, and another thing also would be important is because before you go to tax court, if you happen to end up there, you want to have done your Freedom of Information Act request to get information first before you go in there, which is scheduled to be in a class 9. So it's better if I cover that class first as well, and then get into tax court. For all those reasons, because the foundation needs to be laid, it's better to do that. And so we're going to do class class 7, which is more court procedures. We're going to do that tonight. This class, the 6th class. What was to be analysis of the court case, which was to be 8th class, will be the 7th class. And then what was to be class 9 on Freedom of Information Act. And also bankruptcy to discharge taxes and debts. We're going to do that in 8th class. And the last class we'll talk about how to handle administrative proceedings, and in particular the tax court. And so that's going to be a different thing from this level 2 than the level 2 we had before. But got some interesting news to share with you guys in that I filed today in the Court of Appeal in the California District Court of Appeal a writ of mandate against Superior Court judges because these guys are really out of hand. To put it in a nutshell, municipal court judges have been removing court records, and that means when I file paperwork in court, the clerks don't like it. Guess what? The clerk gives it back to you. She can't do that, or he can't do that. That's a removal of government records. Okay, once its stamp of the clerk goes on, it's part of the court record. They cannot give it back to you. And worse yet, I found out that when you write a complaint to the grand jury, as I had done in March of 1996, complaining about removal of court records and other obstructions and perversion of justice by the judges or clerks, that complaint will end up in your own traffic file, like it happened in my case. And when I told the Superior Court judges about it, they're supposed to be snitches against each other. They're supposed to correct each other and take or initiate disciplinary action. Of course, they don't do that. On top of that, the judges in Orange County have been packing the grand jury with their own people. They put people that are either they're close to the public employees and elected officials of Orange County, of course, in particular the judges themselves. And no matter how many applicants apply, like we had 163 that applied in Orange County, with me one of them, they cut them down to only 30 people that the judges pick. And out of those 30, then 19 of them are the grand jurors. Gee, that's supposed to be a real random drawing, huh? And they pack the 30 with their people. So that's why these grand jurors are not acting on the judges. And the judges are subject to investigation and inquiry of the grand jury. And by doing this, the judges are shielding themselves from all this. So I've been waiting to do this writ of mandate a while ago, but I've been so busy. But it's kind of good that it actually got delayed like this, because now I not only challenge the fact that the grand jury has a duty to inquire in California under Penal Code 919C into corrupt misconduct in office of judges, but also the fact that in how they've been stacking the grand juries in Orange County, and I'm sure much of the state. L.A. I bet is like that, and San Diego, the big counties, I bet you they're like that too in a big way. Attacking that system because the grand jury is not doing the proper check like it should be, and on top of that, what I'm really excited the most is really the fact that the judges now are required, with this ruling, to snitch on each other as they're supposed to. When another judge they found is doing the wrong thing, they are supposed to speak up and take action. So when I win this case, and I believe it's just a matter of going to higher court if necessary, because the law is all right there. It's black and white. Some of you in the class have actually proofread the material for me before I sent it in. You can go, if you find a judge doing the wrong unprofessional conduct, to any judge out there, and now you put that judge on a hot seat to take action against the other judge. That's the importance of it. And if he doesn't, you can go on a writ of mandate, forcing him to do so. So there's more than one way to skin a cat. You know, they cannot close justice for you from all angles. They try to. Anyhow, let's talk about the subject of tonight's class, though, and that is objections. Objections are a very key part of handling bureaucrats as well as handling things in court, as well as in discovery. In fact, that's what you keep hearing. You know, you go to a court proceeding or something of that nature, you hear objection, Your Honor, and all that. What's that all about? What does it mean? What are the different objections? Well, my goal tonight is to go over for you a lot of those. I cannot go over everything, and I cannot go over everything completely, but I'm going to try to do for you a nutshell of the various key objections so that you have a familiarity with the use of objections and the basic ones, because let's face it, the basics ones is what you really use most of the time anyhow. Excuse me. First of all, what I used as reference material for tonight's class, which I recommend you might want to get that or something like it, is Shepard's Quick Reference Guide to Trial Objections. And it's one of those little booklets, only about, just about 100 pages, that gives you a lot of different objections in a real summary fashion, what they are. And this is what lawyers use when they're in court. Quick reference guide. That's all you need. You don't need the fancy schmancy ones. Not in trial, not in court, not in a deposition. If you want to know why, because the only time you need the real advanced detail stuff is when you end up, making an objection and the judge goes against you. And then you need to take that to court and argue why your objection was a good one. Then you need to argue it and research your objection out thoroughly. But at the time you make the objection, you got to make it right there. Snapshot decision. So your understanding of the basics of what's here is what is the most important thing. The thing about objections is, first of all, if you're in a court, you have to make them right there. You cannot get up and say, Your Honor, that question that was asked 10 minutes ago of that witness, I have an objection to that. I don't think that question should have been asked and answered. You can't do that. Can you imagine? We'll have chaos in the courtroom. Hey, well, what was said 10 minutes ago exactly? And, let's read the transcript. Who remembers what was said 10 minutes ago or half hour ago? So that's the reason why objections, you got to be made right away. Objection to what? Well, you could object to, you might want to write this down, a question being asked of a witness to provide an answer. That question should not be asked because it's improper for whatever reason. So therefore, the witness doesn't have to give an answer, or some evidence is being attempted to enter into the record that you are against, that you believe should not be admitted for whatever reason. That is basically it. The two big arenas. I mean, let's face it. Either someone's going to say something, or you're going to check out something. So those are two areas that objections are made. You want to keep some evidence out, or keep some line of questioning that will bring some answers out, because they're improper. So the objection's got to be made on the spot. So generally, if a question is being said, within maybe 5 to 10 seconds after the question is completely said, you can make an objection, and the judge will rule on it. You can make an objection, by the way, in the middle of a question, which is very often you'll get that. Why? Because in order for you to object to something, to know if it's objectionable, you don't necessarily have to hear the whole question. You can see where the question is going, what it's basically about, and if it's objectionable, you object right around the half of it, or middle of it, or up front. But if you wait till the end, which is okay, obviously you have a few seconds to think about it. Now, how long do you have? Well, that's 5 seconds, 10 seconds, more or less. Well, that all depends on the judge, and how long the question is, and how complicated it is. And there's no hard, fast rule on that, or how forceful do you want to be that that's an important objection, even though 20 cents, or 15 seconds went by, rather than maybe 2-3 seconds at the end of the question. Okay, it's subject to debate, but the idea is you got to make it as soon as possible. The other point about objections: some of you have seen in movies that lawyers get up when they make objections, right? You don't have to do that. You can make your objections just sitting down. That's fine. You don't have to raise your arm either. All you need to do, technically, legally speaking, is open your mouth. The reason you see on movies that the attorneys get up is twofold. Number one, you gotta remember, you watched a movie, and certainly someone standing up is more dramatic than someone just saying something, right? So movies are always trying to make things more dramatic, so that's why the person gets up. And a movie is more of a dramatic thing. Secondly, lawyers are taught generally that you gotta be forceful, you gotta be assertive. So standing up, you are making more of a forceful objection, you could say, because you're physically getting up. But you don't have to do that. Sometimes you might want to, sometimes you do. That's not the important thing. The important thing is the mental process that goes into it about objections. Okay. Did you get one of these handouts? Okay, we're going to go over that. Alright, so you can make your objection sitting down. When an objection is made, the judges have heard so many cases as a judge, and judges are usually, of course, or retired lawyers, whatever, from their own experience. They are familiar with objections in a pretty general way. So when you object to something, you don't have to say up front on what grounds you're objecting to. But the judge might ask you to. So you want to know, obviously, why you're objecting. And I tell you, it's one of the most fun areas that you can have is objection. I know in my tax court case, the Irish attorney thought this was in discovery, where he didn't give me anything. He shut me out, didn't answer nothing. And then at trial, he didn't want me to ask anything. So he just kept objection, and the judge had to shut him down several times until he learned his lesson, that don't just object for the sake of objecting, Just sit down. If you see a good reason, object. So that will happen to you too. If the side just keeps objecting for So, what was I at? Sorry, I lost my train of thought for a second.
You were in tax court thinking of
Yeah, before that, before tax court. What was I talking about before you get to tax court was, okay.
the grounds for your objection.
The grounds for your objection, yes, you don't have to say it. The judge knows what your objections are. Usually they're pretty obvious, but not necessarily, as you'll see. Okay, one of my favorite objections. Let's turn off the tape for a second. I gotta get something for you guys.
Red button, right?
No, the big one in the back.
Okay. Yeah. All right.
Okay, you didn't hit it off. Hit it hard. Okay, now I'm gonna cover some objections. We're gonna cover a lot. Some we're not gonna cover that much or at all. The first one I'm gonna start out with is the one. It's my favorite objection of all to government harassments, and that is a lack of foundation and the best evidence rule. Now, I've covered these things in complete detail as much as I could in the course How to Beat State Income Taxing Agencies. In a nutshell, the state income taxing agencies, as far as even the feds to a good degree, as well as any government administrative agency, they are so lazy and inefficient that they don't want to gather enough evidence to make their case, or even make the minimum of foundation for their case, if as the case may be. So they try to really bulldoze you and into pleading guilty or capitulating to them. And it's a very big thing. You don't do that. Don't assume things. Okay? Lack of foundation means that let's put it this way. I turn here to Rich and say, Rich, when did you stop beating your mother-in-law? Now, Rich could have a mother-in-law, and he could have been beating her a while back, and on his own he's thinking, gosh, how did you know about that I used to beat her up, that I haven't beat her up, I haven't stopped yet, or how did you know that I stopped only a year ago? You know, he could be going through those things, or think, did I ever beat her up? 5 years ago, 10 years ago? I don't know, did I? He could be having all these thoughts going through his head, right? Whether they're true or not. He could actually be guilty of that, technically. Yes.
Doesn't he have to establish the fact that I started beating her at one point?
Well, before that, though, let's talk about this. So that's one of the things that the guy got to establish, that he beat her, right? Okay, what else they got the other side? They got to prove before that. Before even the fact that he beat her, what else they got to prove?
Opportunity.
What's that?
Opportunity.
He had the opportunity to beat her? Okay, well, if he beat her, obviously that shows that he had the opportunity. So that takes care of that point. What else? Motive, if you beat her, if he shows he beat her, the motive was there, right? If
she's filed a complaint, or she's
filed a complaint, well, that's not necessary. If she's got witnesses, that will do the trick.
Does he have a mother-in-law?
Say it again?
Does he even have a mother-in-law?
Oh, okay. Something more fundamental we didn't think. You see, I used to be like that too. It's like, oh, that's right. Does he even have a mother-in-law? Okay, well, but before that, what else? What do we got to establish before that? If he has a mother-in-law,
Was he ever married?
Was he ever married? Which means, does he even have a wife, or does he ever been married? Right? So does he have a wife now, or ever? To have a mother-in-law, to have beaten her. Right? You see how just asking that question out of the blue, it's inappropriate? Because the elements of that question haven't been laid yet. Now again, as I gave you an example, Rich could really have a mother-in-law that he's still beating, or he stopped beating a year ago. I don't know. Okay? And he could be sweating it while that question is asked. And he forgets to say, objection. Why? Lacks foundation. In fact, the judge will know right up the front when he says something like that he forgot to lay the foundation. So what the other side will have to say is, okay, Rich, Are you married? And Rich will say, yes, I am, if he is. Okay. Does your wife have a mother? Yes, she does. Okay. Did you ever beat her? Oh, yes, I used to beat her years ago. Okay. Now that we established all that, when did you stop beating her? Which, of course, he would not even get to, because if he ever the other side asks you, did you ever beat her, what would be your response to that?
Take the Fifth Amendment in case it's never been criminally prosecuted.
That's right. I mean, I'm not saying beat up your mother-in-law, okay? That's not what I'm trying to say, but as I'm just giving a classical example that he could take the Fifth Amendment to that question. He could say, no, I never beat her up, or he could say, I take the Fifth Amendment to that. So if with that Fifth Amendment, if it cannot be established that he ever beat her up, how could he have ever stopped beating her? Now, I know this sounds simple, and maybe I'm going a little slow for some of you, but I cannot really overemphasize the importance of having this simple thought process of what are the elements that go into it before you get to the next stage, as how important it is when you are in court. Or, or for example, Dave was asking me something about something, and I said, you have the answer. You just gotta sit down and think it through. I could not give you the answer in 2 minutes as much as I wish I could, because I gotta sit down like you and think it through, these different elements, and come up with the answers. So once you understand this process, no matter where you are, where you have no counsel, no one to help your preparation on your own, you can give it enough time, analyze it, and think it through, and come up with the right answer. Okay, so lack of foundation is critical, and you always had your guard up. I'll give it one time when I got tripped up about it, okay? So you do know. On my traffic case one time that I had, and the failure to appear charge. First of all, I didn't have a counsel, and I told the judge, when he questions me, I want counsel because I won't be able to object and answer at the same time. I cannot be counsel and witness at the same time. Just for this part that he's questioning me, give me counsel, and I think he should have. I think it's fair, doesn't it? How can you think of the answer and the objection at the same time? It's kind of difficult, isn't it?
You're the one that decided to do it without.
I'm the one that decided to do it without an attorney, he says. That's what the judge claims. So anyhow, fine. Well, the problem came that, there wasn't a big problem that didn't cause me a problem, but he said at one time, he was asking me, well, earlier you said that you were an attorney for the courts, and he said, aren't you pretty familiar with the way the courts operate? And I said, well, I don't know, maybe somewhat, I don't know. Whatever answer I gave. But you see, he never asked me if I was an interpreter on the record. I had social conversations with this deputy district attorney, which I've told him I've been a court interpreter, stuff like that from time to time. But when he asked me that, earlier you said that you were a court interpreter, in my mind it didn't register that I had not said that on the record. So as far as the record was concerned, that had not been established yet. But I just late for him. Okay? And then the other thing was that with that not having that step, he kind of caught me off guard because he got that in there. I was not quite prepared to answer the next one as best as I could have, perhaps. So that's another advantage why if you go to court, even if you decide to represent yourself, I think you could get an attorney as counsel to advise you to a strong point. Get an attorney be in court, especially when you're testifying yourself, if you testify, because you have a difficult challenge of being a witness and a counsel for yourself at the same time. Okay. The other favorite of my objections is the best evidence rule. The best evidence rule is that generally speaking, only the very best evidence that's available is admissible in the court of law. Well, what's generally the very best evidence? Well, that's almost always, not always though, the original of something. Or a certified copy of something. Okay? Not a copy. Not a photocopy. Not a fax copy. Not a computer printout. Okay, we're going to cover those things. Why? Because if I'm going to give you a copy of this piece of paper, I could easily white it out, some things written on there, write something totally opposite on that line, photocopy it, and give you that copy. And you think it's the original, even though it's a copy. So copies could be easily tampered with. That's why you always want original. Okay? Now, what's a certified copy? Let's clarify what certification means. Certification means that a third party, generally a government official, but doesn't have to be really, that doesn't have to be necessarily a government official, has certified, put themselves under oath, that say that, hey, under oath I declare this is a copy of the original. And you can do that. You could take a piece of paper, take it to a notary public and say, Rob, I want a certified copy of this, Mr. Notary Public. Rob says, okay, fine. My Notary Public fee, I don't know, it's $5. He takes your money, and he makes a photocopy of that original, and then puts his seal, his stamp on there, signs it, that on this date, this document was given to me, the original was shown to me, and this copy that I made and I'm sealing is a copy of the original. So we know that that document is exactly the same as the original because somebody else, some third party, at that time put themselves under penalty of perjury, under the risk that that's as good as the original. Okay, later on we can bring that person in on that certification. Okay, and they got that seal on there and all that information on there. Now, and that person, generally, of course, and they always use also color, oftentimes seals, but it doesn't have to be. It could be black, but red and blue and pink, all those things have been used. See, that's why, for example, when I went to my traffic court file, and I found in there the original letter of my complaint to the grand jury in March 23rd, 1996, about removal of court records by the clerks of the court and other obstructions of justice. I found the original on there. What could I do? Could I take that original, put it in my pocket, in my files, to take to court to see what they've done? Of course not. But what I did do is have the court clerk right there say, okay, please, Mr. Harach was his name, give me a certified copy. So he made a photocopy. Then he put his seal on there, stamped it, dated it, signed it, that this is the same as the original. I certify that the foregoing instrument is a true, correct copy of the original on file in this office. And he charged me, and I happily paid. Small investment. They charge you like $1 per page for these things. They make like a bandit for these things. But, worth it. Now, tomorrow, by the way, this is what I was going to tell you guys. 10 o'clock in the morning, I have an appointment with the district attorney, head special investigation, who looks into corrupt government officials. I met with him before. He wants to see the original of these documents and the receipt. So I'm going to go there with my tape recorder, and I can have 1 or 2 people with me. If any of you interested, let me know tomorrow morning at 10, Santa Ana. You guys can come. Anyhow, it's fun. So that I can take that, and then he's going to see that. He's going to see my certified copy. Now, the photocopy that I made is not good. It's only good to show somebody that, look, such a thing exists, right? The photocopy I made, and I made lots of photocopies of this document. Those who in the live class know. But the bottom line is that whoever is going to be eventually judging this thing in a court of law, they say, gosh, I really want to check that. I want to compare the copy with the original. Now let me see. Has anything been changed? Anything deleted? Anything marked over? Okay. In fact, in a court of law, or any kind of a tribunal proceedings, when you introduce the original, now this isn't, write this down, you guys. When you want to introduce a document, you got to give a copy of it to the other side beforehand, so they know what you're going to be introducing, so they can object to it beforehand. Okay, and generally, almost always, everybody agrees or stipulates to stipulate, which means we just agree, assume to. That you give each other the copy of the documents you want to introduce, and the other side can inspect them at will anytime to make sure the copy that they got is a true copy of the original. And that sounds fair. So everybody retains the originals, and you got the the copy there the other side has. That way you can compare it. So it's a very meticulous key thing. This is one of the things, for example, that in O.J. Simpson case, it was attacked. The evidentiary foundation, all these tampering with the evidence with O.J. Simpson case came under attack because the Los Angeles Police Department did a very poor job of doing these things. Now, with photocopies is a good example, is a very simple example, but again, O.J. Simpson case, you got genetic material. I mean, that's a lab with blood and lab material, and dust on the bottom of the shoes and things like that, which is even more complicated. It's very important to preserve the chain of information.